Hi, I'm Steve Vest, host of FPB's Meet the Candidates. This Cable 10 series allows you, the voter, to hear directly from the candidates on their views on issues that are important to us. This is leading up to the general election on November 5th. Today's guest is Erin Izzo, and she is a candidate for Kentucky Supreme Court, 5th District. Erin, thanks for joining us today and stopping by for a visit.
Thank you very much. I appreciate the opportunity to come here and talk to everyone. My husband and I, we live here in Frankfort, and so it was just around our neck of the woods anyway.
Yeah.
So thank you very much. I'm pleased to be here.
Okay. Well, could you just tell us a little bit about yourself?
Sure. How far back you want me to go?
As far as you want.
All right. All right. Well, I'm a native Kentuckian.
Mm-hmm.
I was born down in Tennessee when my parents moved out of state, but my family's been here since before the Revolutionary War.
Mm-hmm.
I graduated from Ballard High School up in Louisville, and then went to Dartmouth College for undergraduate, and then came back after that to go to University of Kentucky for law school. And I've been in Central Kentucky ever since. I'm currently a partner at Landrum and Schaus in our Lexington office, where I am an arbitrator and I'm a mediator. Also have some litigation cases still going on with it, but that's what I do, and so here I am.
Well, and outside of the law, you said your husband and you live here in Frankfort.
Yes, we do.
Okay.
Outside of the law, goodness, my extracurriculars, so to speak,
Yeah.
are still pretty law oriented. I'm on the board with the Kentucky High School Mock Trial Association, and have been active with that organization since about 2006. I also I call myself the Pumpkin Lady for Greenhouse 17, which is a domestic violence shelter in Kentucky. And what I do with that is I donate them pumpkins every year for their Halloween festivals, and I've been doing that since about 2007 or so as well.
Okay.
So there's different things that I do.
Okay. Well, what role, if any, do you believe your background and personal experiences play in your approach to the law and judicial decision making?
Very good question on that. I think my background is pretty comprehensive in that I have a wide range of experience and people that I'm close to. My family has both the white collar and blue collar people in it, so I've really valued the importance of having input from someone who doesn't necessarily have a bunch of letters behind their name. One thing I've told the kids at the high schools, North Oldham and Lexington Catholic here earlier this year, is that every person that you meet in life is going to know something that you don't, and that's as true for me as it is for you. I mean,
right.
That's just something that we have to learn to respect and to hold dear. So with that background, I'm certainly open to different things and different perspectives with it all. Experience-wise, professionally, I have litigated complex cases for 19 years at all levels of the courts, from pre-trial to trial through appeals at the Court of Appeals and the Kentucky Supreme Court, and even up to the U.S. Supreme Court. And it's that sort of comprehensive experience that you really need to have as a background before you go on the bench to really understand the impact of cases that are brought before you.
Okay. How would you describe your judicial philosophy?
Sure, thank you. I consider myself to be a constitutional originalist. For those who want to know what that is, basically that means looking to what the Founding Fathers, at least in terms of the Constitution, looking back to what the Founding Fathers meant by the language that they used when they actually enacted it and adopted it. Because words back then, or goals that they had in mind then, aren't necessarily evident from the text of the language itself. With that and other perspectives, like say we're dealing with something like the Civil Rights Act, for instance, then it's the same thing. You go back to when the law was enacted to see what was at issue, what was it meant to address, because without really putting the law into context, you don't truly understand what it's meant to accomplish.
Okay. Can you provide an example of a Kentucky Supreme Court decision that you agree with or disagree with and explain?
Oh, my goodness, wide choices here. How about I'll pick one of my own. This was a case. It was Morgan and Pottinger versus Noel Mark Botts, or it might be versus Noel Mark Botts versus Morgan and Pottinger. I forget which it was. That was a case that dealt with the judicial statements privilege in there, and it was one that I litigated up earlier on in my career. That is a published decision and is binding on all of our courts today. What was involved in that case had to do with a bar complaint. If attorneys aren't doing something that citizens feel is not correct, you can file a complaint with the Bar Association, and they will look into it and investigate it. Well, this bar complaint that it had been investigated by one of the other parties in the case. They had filed it against the other attorney, and I actually was representing the law firm that was representing the client with that bar complaint. So you can see it was kind of a mix in there. After the bar complaint was dismissed, then the attorney filed civil suit and saying that he had been defamed, that there was slander involved with all of it. And so a lot of the argument there was saying, no, the act of filing the complaint and putting those statements in before the court, that itself is protected as a statement before the court. So I was arguing immunity was attaching because of that. The Supreme Court agreed with it, and so I appreciate that. It's always good to know your arguments work. But it's important because something as simple as that hadn't been the law in Kentucky. You didn't know if when you filed a complaint, if someone was going to all of a sudden come back and sue you because you filed the complaint.
Right.
And so this extended that protection in there to make it clear for everyone, whether they're plaintiffs or defendants, when you have something like that that's filed in the pleadings, that you are protected by that. Someone's not going to be able to come after you and try to argue otherwise.
Okay. Mm-hmm. All right. Well, what factors do you consider most important when making a decision on a case?
The law. How about that? Number one is the law.
Mm-hmm.
And when you look at the law with it, because I deal a lot of this with my arbitrations. I am an arbitrator and have been arbitrating cases for 8 years. And these are cases that people bring to me. So they trust my decision making, because if they didn't, I wouldn't have these cases with it. But looking at the law and seeing what the law says, you look at it by its plain language. If there's any ambiguity in the language, that's when you go to the legislative intent to see what is going on there and what it's intended to mean. Then there's precedent with binding decisions. You look at it and see how the courts have looked at it in the past, because all of that impacts your decision making in that particular case. So that's the first factor, would be the law. Two, the facts of the case.
Yeah.
Again, something so simple with it all, but case context will change the decision that you make depending on what happens in that. And it's why I joke that attorneys will never be without employment, because every case in Kentucky has some sort of distinguishing characteristics based on the facts that are involved.
Right.
So you've got the law first, you've got the facts of the case next. Goodness, trying to think what else would be, and those are the two big ones. How about I just stick with that?
That's fine.
All right.
Well, how do you personally ensure that your beliefs and biases do not affect your decisions on the bench?
Excellent question. And this is something that I really hold dear, because without an independent judiciary, you're not going to be confident in the decisions that they reach in these cases here. So it's something that, of course, I obviously have a lot of personal beliefs, as do you.
Yeah.
But those have to be set aside. Judges, arbitrators, we're neutrals. We are intended to be able to have the ability to set those passions, those prejudices to the side when we're making our decisions based on what the law is. And to quote my favorite U.S. Supreme Court Justice, Justice Antonin Scalia, and this is paraphrasing, of course.
That was my next question. Yeah. Who's your favorite?
Scalia. So I'll just put that out there.
Okay.
Because he's also considered the originator of constitutional originalism. He's the founder of the creator of it, and he's credited with that. But one thing that he said is, like, if you're doing your job properly as a neutral, as a judge, as an arbitrator, you look to the law and you reach the decision that the law tells you to make. And if you don't like your decision, then you probably made the right choice. You're doing your job correctly. That's not to say you're not going to like everything. But the point he was making is that if you like your decision, every single decision that you make, then you're probably doing something wrong here.
Right.
Yeah.
Yeah. Okay.
Mm-hmm.
What do you see as the most significant legal issues currently facing the Kentucky Supreme Court?
Oh, wow. All right. And I have to tread carefully with this.
Yeah.
Because a judicial candidate, we're treated differently than legislative candidates. We're not allowed to give our opinions on any of the issues that could come before us in court. So I can tell you these issues that I see, but I can't give you my opinion on what I think of them, because because they are pretty hot topics out there. The chances are high that they would come before me here.
Yeah.
One, you've got the school choice amendment 2 that's on there that is everyone is really, really paying attention to, which I think is good. You also have the abortion issue that is out there, and women's rights, and those are 2 really big ones that are out there that are really getting everyone's attention. I think gun rights are also out there, because there's been a lot of movement in that, and I would not be surprised to see all 3 come up before me on the bench.
Okay. Mm-hmm. Well, how do you view the role of ethics and judicial conduct in maintaining public trust in the judiciary?
It's key. It's absolutely key. You have to have an ethical bench so that way the public has confidence in the decisions that are being made. And this is one point that really differentiates me from my opponent, is that I take this stuff seriously. There was one instance, I think we all remember the Comair decision, or the Comair case with the plane crash. Well, my opponent had despite all the ethical concerns and making sure there are no conflicts, she recused from the civil action but not from the criminal action. And then in the criminal action, recommended and actually sentenced the individual to a lesser sentence than what the prosecutor had recommended. And so that's an issue. That right there really undermines the confidence that people will have in their courts, because they don't know if the decisions are coming down to playing favorites. It's really highlights the need of the independent judiciary. And as a member of the bar, we already have our code of professional responsibility that attorneys are obligated to uphold at all times. In addition to that, the judges also have the judicial canons that instruct them on how to operate, how to make sure that they have everything stay neutral. So it's absolutely imperative that we keep it like that.
Okay. Well, what steps would you take would you handle a situation where you might have a potential conflict of interest in a case before the court?
Wonderful question, because this has come up in my arbitrations, so it's something that I have dealt with. It's not just where you might have a conflict, or if you do have a conflict. Under the canons, under the judicial code, and under the code of professional responsibility, it's not just if you actually have an actual conflict. If there's an appearance that there may be a conflict, then judges should recuse themselves. And the point with that is if you look at something and because of either the relationship that a judge has with one of the parties or one of the party's family members or whatnot, the outside public could look at that and say, something's not quite right here. And that doesn't mean that the judge is actually doing anything offhanded, but because of that perception, it's imperative in those instances for the judge to really look at it and say, okay, is this a conflict? Is this something that could call my decisions into question? And if so, recuse off the case. And so I've had that happen in arbitrations before me where I've checked. I've said, wait a minute here. It's either I've represented a person by this name and I'll check into it and I'll look into that more to see whether or not there is a conflict. Or if it's someone, for instance, because I do still litigate, is it someone that I'm litigating against? Well, then I'm very careful with those cases as to whether or not I'm actually arbitrating a case where a person that I'm litigating against is coming before me. So these are things that we need to keep a staunch watch on to make sure that we can maintain the integrity of the judiciary.
Okay. Well, what do you believe the role of the judiciary is in safeguarding the democracy and the rule of law?
I think it's key. How about that? This is something where you have the three branches of government that our founding fathers put together there. And each of them have certain powers that have been conferred upon them. There's a system of checks and balances with everything in place. And it's, in my opinion, it's the judiciary that really ensures that these checks and balances are met. That's why we have the different cases that are out there where the judiciary is saying, look, no, legislature, you are not able to make this decision or do this action. This is a judicial function, or you're not allowed to do that because it's executive. Executive, you're not allowed to do this because it's judicial or legislative, and vice versa. And even with the judiciary, making sure that we don't encroach onto the powers of the other branches here. And it's the role of the judiciary to make these findings because we are to be the neutrals. And so the public is trusting us with that, and we need to be able to do our job.
Okay. What is your stance on transparency in the judicial process, including the use of cameras in courtrooms?
Okay. How do you mean the transparency? Just that we use cameras in there, or what in particular?
Transparency in actions, but also the use of cameras in the courtroom so people can see what's going on themselves.
Well, this is something that's really great, I think, because back in the day, we didn't have the cameras. You had court reporters who were literally typing everything up with their 10 key pad. Now we have it on video, which makes it run more smoothly for our clerks there to have it. It's also easier for people to get a hold of the records, and it preserves the records where you can see where someone's standing. You can see if they're moving a certain way, if their eyes are fidgety or whatnot, that you don't get from just a transcript in there. So I think it's very good from that standpoint in there. It can be messy sometimes because it only records what the microphones will pick up.
Right.
So if you have someone who's standing too far away from the microphones, then they're not going to hear it. And then there's no transcript to back up what actually happened. So a lot of that in my law clerk days, I'm here listening to it, my ear pressed up to the speaker trying to figure out what was going on in court that day. So it can be detrimental to that effect. I think the fact that we had this going when COVID hit was just wonderful. It allowed, it allowed the courts to continue during the pandemic, even though we had to put a hold on the civil cases, so the criminal cases would take priority because of the right to a speedy trial. But even after COVID, with that, it's provided another means for the courts to actually go through with their cases. You can have the conferencing with inmates at the local detention center. You can have them come in there, or you can have witnesses testify through the Zoom conferencing. Even attorneys now will appear in court through the Zoom conferencing or through a teleconferencing. And so it really opened up everyone's eyes into how other things could take place in the court system. So I think overall it's good. There are little hiccups from time to time, but I think it's definitely
people showing up in their pajamas or something like that.
Well, what's the joke? You have the legal mullet, I say, where everyone's sitting, where you've got the suits from waist up, and then you got the pajama pants from waist down.
That's right.
Or you show up as a cat. Right?
Oh yeah, the guy that had the
right.
Yeah.
So there are snafus that could happen at times, but I say overall it's pretty good.
Right. Yeah, I am not a cat.
You are not a cat. Good.
Yeah. How would you work to improve efficiency in the court system?
In how cases proceed or getting to the courts? How do you mean?
The efficiency, time, organization, while still maintaining the due process.
And that's
things moving along more quickly, but.
Well, good luck with that. I think litigators will probably keep it going as slow as they can sometimes.
Yeah.
I think one of the things that would really help with this is maybe developing a way for the courts to know, among other courts, what's happening in these cases. Something that I've heard in my campaign, on my campaign trail, is that the frustration that people will find, you see this more in law enforcement or even with other people in the criminal context, they'll come in, they'll say, well, this person so-and-so is out on bond in another county here. Why doesn't the court know about it? Why aren't they picking them up? Or there's been a violation. And there seems to be kind of a wall between the courts. And I don't know what sort of system could be put in place, whether it's in pretrial services or as part of the PSI or whatnot, in terms of interviewing, to have more communication between there. So it can speed it up, where if someone's an offender in one case and they appear in another case, then you can have law enforcement pick them up in that one, and kind of aids in the process moving along more smoothly.
Okay. How do you interpret the relationship between state and federal law, particularly when they may be in conflict?
Depends on what it is that's in conflict. Of course, you have federal preemption that takes place in there, and so a lot of it, if it's handling with that and the preemption, then you've got to follow the state law. But I think we're going to see a lot of this here come into conflict, especially as it concerns the Title IX and Title VII aspect of the federal law, because of how the state courts have handled this. And this is an area that I've litigated for many years. You're talking about discrimination cases with the Civil Rights Act. Title IX is dealing with gender discrimination in sports, and how I think it's coming up. And so you'll see me kind of walk around this here, because I do think it's really something that I will see in there. You have the Title IX decision, where so far, at least now, gender is based on biological sex, male and female. The same word, sex, is used in Title IX as it is in Title VII. Title VII, it's meant to include things not just biological sex, and includes sexual harassment. It can use sexual orientation. It has expanded. It's kind of working its way towards transgender issues and gender identity. In fact, there was a bill that in the Kentucky legislature that it did not go anywhere. I forget exactly where in the process it finished, but it was to amend the Kentucky's version of the Civil Rights Act to include gender identity as a protected class. Now, Kentucky's state courts here, when they're interpreting these laws, will typically follow the federal analysis.
Right.
Well, that's at odds with a lot of the decisions here. With what we've seen go on with Title IX, it's at odds with a lot of the decisions. So I'm curious to see how that's going to pan out in the few months before the election, and then I'm curious to see what will happen with the cases that will come before me.
Okay. Well, what do you believe would be the most pressing legal challenges for Kentucky over the next decade, and how do you see the Supreme Court's role in addressing these challenges?
Wow, that's a big question.
Looking into the future.
Predicting the future, right?
Yeah.
Well, getting with the big issues I think that we're going to see. We're going to see abortion issues come up. We're going to see the transgender gender identity issues come up. Those are at the forefront, as well as this education choice with Amendment 2 that's coming up. The judiciary, though, and how the judiciary reacts to these things, and I say this, it's as equally true for an arbitrator as it is for a judge, we're dependent on what the people bring to us. So it can all go to heck in a handbasket, so to speak, but if it doesn't come before the judiciary in a case, there's not much the judiciary can do about it. Not only that, a lot of it has to be teed up in a proper way. There's got to be proper standing of the people who are actually bringing the claims in there. And you've got to look and see what law is at issue with a particular case. Of the three branches of government, the judiciary, and this is something that I've described to people, the judiciary is more of a reactionary branch in the sense that judges live in bubbles. Yeah. That's not my words. That's I credit that to Judge Lucy Van Meter out of Fayette Circuit Court. She told that to a panel of women here about 2 weeks ago, that judges live in bubbles. We're dependent on what the people bring to us. So we could see all of these issues going on, especially when you have the due process issues that we see going on in the federal courts with different cases that have gone on here recently that are in the news. We can scream and yell about it all we want to personally, but unless someone actually brings that to us before us in a case, there's not much we can do about it.
All right. Okay. How are you uniquely qualified for this position as opposed to your opponent?
Yes, spot on. I do believe that I am the more qualified candidate for this position by simple virtue of the fact that I'm the only one that has the litigation experience. I've litigated for 19 years of it, and you see every single justice that's sitting on our Supreme Court now, every one of them litigated for at least 10 years before they got on the bench to decide a case anywhere. I have the 19 years. Even then, I had 11 years before I started arbitrating cases, so I still have that in there. My opponent only has 5 years. And it shows in her decision making. A lot of it misses the point on the law, a lot of it misconstrues the law, and thankfully the Supreme Court has called her on it many times in there, and I'll be able to get into that further here, I think beginning in another week or two with that. The litigation experience, why it's key, goes back to judges living in the bubble. Unless you've actually litigated these cases, you don't understand how the law actually, the effect that it has on the people that are involved in the case. A lot of times there are other things that are going on, like how someone is going to be able to pay their mortgage or their rent because of an injury that they've had and they're out of work. The judge doesn't get to hear that. So unless you really bring that up before the judge, they're not going to know it. And if they don't have the litigation experience, they're going to have no idea what they're doing. This is something that is really key. I think that's why Kentuckians have insisted that their Supreme Court justices have this experience. Myself, I have litigated, mediated, or arbitrated cases in more than 90 counties across the state. My opponent, she's litigated cases in 2 counties, and most of them were in Fayette, where she was there on the bench. Her cases that she has litigated, from what I can tell, are domestic disputes, maybe a warning order attorney or a guardian ad litem, not anything on appeal. She's had no appellate experience before either the Court of Appeals or the Kentucky Supreme Court, whereas I've got published decisions. So it's a difference. I'm familiar with the process. Part of it's also rung true on the campaign trail, where my opponent's made statements that shows that she doesn't know the appellate rules of the court that she wants to go and sit on and preside on. This being one of the statements that she did make in Jessamine County, I believe it was, is that that if you count all her cases, all of her decisions at the Court of Appeals that have not been appealed further, then she is the most affirmed judge on the Court of Appeals. Well, that shows right there that she doesn't know the rules, because there's a rule specifically in the appellate code that says if a case is not appealed further, it does not count, it is not affirmed, and you're not allowed to tell anyone otherwise. So it shows that she's not familiar with the process, and that can take its toll. when you have the Supreme Court decision, we're not talking about just something that's going to be there for the length of the person's term in office. Mm-hmm. You're there until another factual situation comes up that is similar enough that the court will actually take a look at it. An example that I'll use just to kind of put this in context for everyone is the Roe v. Wade decision here, when that was entered versus the Dobbs decision. Whichever position you take with respect to that, you see how long Roe v. Wade stayed in effect until Dobbs changed the law on it. Now, imagine you have something that's in effect there as it's a decision, it's a bad decision with the Supreme Court. You could end up having that for 30 or 40 years before another situation comes up where the Supreme Court can change things. And so that's why it's imperative that we have someone on the bench that has that prior litigation experience, because that's the only way that we know the case is there. That's the only way that we know the law of these cases. And it's the only way that we know the effect that it'll have on Kentuckians.
Okay. Mm-hmm. Well, now it's going to be your turn. You get to look into the camera and tell people things that I may not have asked, or ask them for their vote. Whatever you'd like.
Absolutely. Okay, well, here I am looking in the camera, right, trying to see which way to go with this. Yes, I want to thank everyone for tuning in to watch this. I welcome your questions with everything, and I hope to earn your vote in November. It's key here. This is a race that I've heard said that is the most important race for Kentuckians after the presidential race. With that, you have justices who are on the bench right now, with Justice Van Meter retiring. There are several that are more left-leaning and several that are more right-leaning. And what will happen with this is that the person who is elected to fill the seat is going to be the fourth person on there for whichever way is the majority for the court. That's why it's imperative that you, as Kentucky, you elect someone on there who has the experience litigating these cases, who the community trusts to bring their cases to in arbitration. At this point here, even though I am still litigating, about 90% of what I do is in arbitration, and that shows that people are comfortable with my decisions. They know that I'm going to apply the law, and they know that I'm going to do it correctly. My decisions and my work on the appellate practice, like I said, I am the only candidate in November that has appellate practice, and I have an 85% success rate on my cases. Actually, more than 85%. Since my campaign started, I've won 2 more cases on appeal, so it's increased with how well I've done on those. So I hope you Kentuckians, I hope that you trust me in November. I welcome any questions. Please check out my Facebook campaign page there. You look for Erin Izzo for the Kentucky Supreme Court, and you will find me there. Send me questions. I do respond to them. I think it surprises some people sometimes, but I do respond to them. You can also check out my regular campaign page at erinizzo.com, and I want to thank you very much for tuning in.
Well, and I'd like to thank you for coming by, Erin, and Erin Izzo, a candidate for the Kentucky Supreme Court. And to our viewers, remember to get out and vote on Tuesday, November 5th, and then tune in to Channel 10 for the election results from the county clerk's office. It's election season. Get informed and voice your choice. We'll see you next time.